Good morning, everybody. Thank you for joining me for today's webinar. My name is Amber Hines, and I'm the owner of Ashbur, where we specialize in Medicaid compliant annuities. Today, we're going to be talking about crisis planning for a married couple. And first, I'm just going to tell you a little bit about myself before we get started. Again, my name is Amber Hines, and I have spent the last 15 plus years working with elder law and estate planning attorneys across the country to help their clients secure Medicaid compliant annuities. I am insurance licensed in all states, and I hold a Series 65 license with FINRA as well. And I created Ashbur to assist advisors and attorneys with pre-planning solutions such as hybrid long-term care insurance policies and crisis planning by way of Medicaid compliant annuities, as well as prepaid funeral policies for their clients. If you have any questions during today's webinar, feel free to type those into the questions bar of the GoToWebinar dashboard. And also, if you're interested in a copy of the materials from today's session, you can download those from the handout section of the GoToWebinar dashboard as well. I'm going to talk just a little bit quickly about how my agency Ashbur can help you and your clients. We offer complimentary case analysis. So if you provide us with information on your clients, such as their assets, income, cost of care, dates of birth, things of that nature, we will help to determine the optimal amount that should be going into the annuity, the term of the annuity that can be considered, and then which assets your clients may consider annuitizing. This becomes especially important when we have clients that have large IRA accounts or existing non-qualified annuities that will prevent them from qualifying for Medicaid. So we can look at doing like a 1035 exchange or another funding mechanism in order to minimize the taxes when purchasing a Medicaid compliant annuity. We offer assistance from the beginning to the end of a case. So we will help with providing quotes for the annuity purchase. We assist with the actual funding of the annuity if that's necessary. And then if you have a situation where a client that purchases an annuity through our office would pass away during the term of the annuity, we will help with settling the death claim process with the insurance company. And if there's a claim to the state Medicaid agency, we would assist with that process as well. We do work with A-rated insurance carriers, and we offer top-notch customer service to all of the agents and attorneys' offices that we work with. Most of the time, we're able to get back to you the same day with a recommendation. We understand that a lot of this work is time sensitive, and so the end of the month is usually pretty busy for us with the clients trying to spend down their assets by the end of a month so that they will be Medicaid eligible for the following month. First, I'm just going to talk a little bit about the difference between pre-planning and crisis planning for long-term care. Pre-planning or proactive planning usually occurs when we have clients that are still considered to be healthy and we don't anticipate them needing any long-term care services in the near future. Pre-planning is always going to be the best planning option for clients because it provides them with the most options as to where they're going to receive care, if that's going to be at home or in an assisted living facility versus a skilled nursing facility that would accept Medicaid. We are able to provide the most options to a client in a pre-planning scenario, just because, I mean, the difference between having a proactive plan and being prepared for something versus being in crisis mode, the pre-planning option is always going to be a better solution for the client, lets them remain in control as to where they're going to receive care and how their assets are going to be spent. From a legal standpoint, usually pre-planning for long-term care is going to involve transferring the majority of the client's non-IRA assets into an irrevocable trust or into a Medicaid trust and waiting out the current 5-year look-back period for Medicaid eligibility purposes. Pre-planning can also involve leveraging the client's assets with a hybrid long-term care insurance policy or even a traditional long-term care insurance policy if that's something that clients are interested in exploring as well. Crisis planning is going to usually involve a client applying for either Medicaid or veterans benefits. And this really takes place when we have clients that are already in need of care, or we anticipate them needing care within the next few months. And at that point, we're no longer able to really look at long-term care insurance or a hybrid long-term care insurance policy for a client that is already in need of care, because they would be considered uninsurable for a long-term care insurance policy. There's various planning strategies that we can use when we are trying to obtain Medicaid or veterans benefits for a client, but it usually involves spending down the client's countable assets and making their countable assets be non-countable assets for Medicaid or VA eligibility purposes. And the main reason why we do that, to convert countable assets into non-countable, would be so that the client would get some financial assistance from either Medicaid or the Veterans Benefits Administration if they are a veteran or a surviving spouse. The different ways to pay for long-term care: first, a client can obviously choose to privately pay or self-insure. Basically, they're just spending down all of their own assets, whether it be money from a checking account, savings, brokerage account, retirement accounts. They're basically spending down dollar for dollar, paying for their own care if they choose to privately pay or self-insure. Another option that can be considered to pay for long-term care would be long-term care insurance, whether it be a traditional long-term care policy or a hybrid. A traditional policy is going to be similar to your auto or homeowner's insurance, where there is no cash value that is accumulating within a traditional contract, but it can provide some long-term care protection for clients that aren't in a position to necessarily buy a hybrid long-term care insurance policy. So they still can be a good option for clients if they are insurable and are looking to protect themselves from a long-term care situation. A hybrid policy is going to involve either combining a life insurance policy or an annuity policy with a long-term care contract, so that if the policy is not used for long-term care, then there would be a residual death benefit or cash value that would be remaining in the policy. That next is the Veterans Aid and Attendance benefit. This can be beneficial if you are working with either a veteran or a surviving spouse. Pension benefit through the Veterans Administration that help pay for care either at home in an assisted living facility or in a skilled long-term care would be talking about today. So today's webinar is really focused on crisis planning for clients, and specifically talking about Medicaid benefits for clients. The basic eligibility criteria in order to qualify for Medicaid: there's going to be non-financial requirements as well as financial requirements. The non-financial requirements include having a client that is a U.S. citizen or a qualified alien. They also must be either age 65 or older, or be considered disabled in order to qualify and meet the non-financial requirements. In order to meet the financial requirements, there's going to be an asset and income test, and usually we need to prove that the clients have limited assets and limited income in order to qualify. In order to qualify from a financial standpoint, the married couple will have both income and asset limitations. The income limitation for a married couple is going to depend whether you are looking at the well spouse or the community spouse. They are entitled to an unlimited amount of monthly income, whereas the Medicaid applicant or the spouse that would be applying for Medicaid is going to be limited to income that is less than their cost of care. Usually this is not hard to achieve if you have a client that's receiving a nominal amount of either Social Security and pension benefit, and you look at a nursing home usually costing around $7,500 or more each month, that's not a hard test to pass as far as proving that the Medicaid applicant's income is less than the cost of care. There are some states that are considered to be income cap states, and if you are in an income cap state, then the Medicaid applicant's income cannot exceed $2,742 each month without establishing a Miller Trust or a qualified income trust in order to have their income flow through the QIT or the Miller Trust in order to establish that they are income eligible for Medicaid. But again, it's important to note that the spouse that is not applying for Medicaid, the community spouse or the well spouse, is entitled to an unlimited amount of income on a monthly basis without having to contribute their income towards the Medicaid applicant's cost of care. From an asset standpoint, usually the spouse that is applying for Medicaid or the institutionalized spouse, the most common asset limitation number is around $2,000 that they are entitled to keep in their name. This does vary from state to state, but the most common asset limitation for an individual that's applying for Medicaid is going to be around $2,000. A community spouse is usually able to keep around 1/2 of the couple's countable assets up to the federal maximum right now is $148,620. This again can vary by state, but the most common maximum for the community spouse to keep is the $148,620. If you have any questions about the numbers in your specific state, you can check our website at ashbur.com, and those have all of our website under the state resources tab will have all of the most recent numbers for your state, both income numbers, asset numbers, and the penalty divisor in your state for making gifts. Other resources that are going to be protected by Medicaid is going to be the home, automobile, household goods and personal property, an irrevocable funeral trust or burial trust, and then some states do consider IRAs to be a non-countable asset as well. This does sometimes vary on whether the IRA is owned by the Medicaid applicant or the community spouse. Like Pennsylvania is a state that will protect the retirement account of the community spouse, but the IRA is going to be countable in the name of the Medicaid applicant. So if you have questions about how your state handles retirement accounts, feel free to reach out to us with questions on that as well. If your Medicaid clients have excess resources, usually we look at developing a Medicaid eligibility plan in order to secure Medicaid eligibility as quickly as possible for those clients. We can consider improving or increasing non-countable assets, such as making improvements to the family home, buying a new car. We can purchase prepaid burial policies for the clients, pay off any credit card debt, mortgage, or other debt that they may have. And then after all of these items are kind of exhausted, these other spend down tools would be considered. We can look at purchasing a Medicaid compliant annuity that would comply with the Deficit Reduction Act of 2005. When we look at Medicaid planning with an annuity, we are always going to be looking at a single premium immediate annuity or a SPIA. And this is a specific type of annuity that is used to convert a lump sum of cash into an irrevocable income stream with the insurance company that the annuity would be purchased through. For Medicaid planning purposes, we would not ever consider using a tax deferred annuity in order to spend down assets, because a tax deferred annuity is going to be treated like a CD at a local bank, because the tax deferred annuity has cash value that the client can access. And so a tax deferred annuity is going to be considered an asset for Medicaid eligibility purposes. As a result of the Deficit Reduction Act of 2005, immediate annuities must meet strict requirements in order for the SPIA to work for Medicaid eligibility purposes. There's only a few different insurance companies across the country that offer a Medicaid compliant annuity. There's hundreds of insurance companies out there that offer immediate annuities, but there's less than 10 companies currently that offer a Medicaid compliant immediate annuity. In order for an annuity to be considered Medicaid compliant, we would have to have the language that you're seeing on the screen here listed within the annuity contract. The contract must be completely irrevocable, meaning that we can't change any aspect of the policy after the contract is issued. So we wouldn't be able to change the annuity payee, the annuity owner, the day of the month that the payments are being deposited into a client's account, or the payment amount. So no aspect of the contract would be able to be changed after the annuity is issued in order to meet the complete irrevocable standard that Medicaid would have. Also, the annuity must be non-assignable, meaning that we can't assign ownership to a company like J.G. Wentworth or Peachtree or to another family member. So in order to meet the non-assignable standard, we would, in some states, need to prove that a company like J.G. Wentworth or Peachtree would not actually purchase the annuity contract for cash. Another requirement of the annuity is that the payments must be equal without any balloon payments or deferral of the payments. Another requirement of the Medicaid compliant annuity is going to be that the contract must be actuarially sound, meaning that the term of the annuity is scheduled to pay out within the client's Medicaid life expectancy, but we can shorten the term of the annuity. So for example, if we have a 95-year-old client who has a remaining life expectancy of 3 years, we could do a 12-month annuity for that client because they are going to receive the full amount of the original investment into the annuity within their Medicaid life expectancy. We just could not do an annuity term that is longer than the life expectancy of the annuity owner in order to meet the actuarially sound test. And then finally, in most cases, the state Medicaid agency must be listed as a remainder death beneficiary on the annuity contract in the event that the annuity owner were to pass away. There is an asterisk there because there are some exceptions to this rule. In some states, we can name the Medicaid applicant as a primary beneficiary, and then in all states, we would be able to name a minor or a disabled child as a beneficiary before the state Medicaid agency. But in most cases that we would be working on, the state would need to be named as a remainder beneficiary on the contract. The different types of assets that can be used to purchase a Medicaid compliant annuity, it's really any type of liquid account, cash account that the client has that can be used to purchase a Medicaid compliant annuity. If your clients have money that's in checking, savings, CDs at a local bank, brokerage accounts, stocks or bonds, a brokerage account, stocks and bonds would need to be liquidated to cash before we transfer them into a Medicaid compliant annuity. But those are all different accounts that could be used to purchase an annuity if your clients own these types of accounts that need to be spent down. Also, if your clients have any whole life insurance policies or non-qualified annuities that they can access for cash, those types of accounts can be used. We can use a 1035 exchange to convert an old annuity or a life insurance policy into a Medicaid compliant annuity and do that with minimal tax consequences as well. And then finally, if your clients have IRAs or other retirement accounts that are going to be considered countable for Medicaid qualification purposes, which I'll be going through later in the webinar, then we can consider using IRA transfer or a rollover to convert those types of countable IRA retirement accounts into an IRA Medicaid compliant annuity. We're going to be looking at a married couple scenario where one spouse is in a nursing home and the other spouse is remaining at home or in the community. The goals when we're applying for or planning for a married couple is to obtain immediate Medicaid eligibility without any kind of penalty period or private pay period for the institutionalized spouse or the Medicaid applicant by converting countable excess resources into an income stream. And then for the community spouse, we want to make sure that they have peace of mind that they will have sufficient income and resources to maintain his or her lifestyle while they're remaining at home in the community. Our scenario today is dealing with Roger and Nancy. Roger is an 85-year-old who has dementia and resides in a nursing home. He has monthly income of $2,000 per month. His monthly nursing home bill is costing $10,000 per month. And Nancy is his wife, who is 80 years of age. She is still remaining at home. She's considered to be the community spouse, and she has monthly income of $1,000 per month. Together, the couple has a home, a car, and $350,000 of non-IRA bank accounts. If the couple does nothing at all and doesn't do any planning, the couple is going to exhaust all of their assets within less than a 3-year time frame. And that was really just determined by taking the $350,000 that the couple has of assets and dividing that by the $10,000 per month that they are currently spending on Roger's care. And that's arriving at a 35-month time frame that they would exhaust all of their assets. That would not be taking into consideration Nancy's expenses on a monthly basis. So that number is actually probably longer than what it would take in order to exhaust all of their assets. When Roger passes away, Nancy will be left with nominal assets and nominal monthly income if they do no planning at all. First, we're going to calculate the spend down amount in order to obtain Medicaid eligibility for Roger. So Roger, as the Medicaid applicant, is going to be able to keep his personal property, a prepaid funeral policy, and $2,000 of the $350,000 in cash assets that they own. Nancy, as the well spouse, is able to keep their home, a car, personal property, a prepaid funeral policy, and then $148,620 of the $350,000 of cash assets that they own together. When we add up the $2,000 that Roger is able to keep plus the $148,620 that Nancy can keep, they have a total protected resource allowance of $150,620. And when we subtract that from the $350,000 of cash assets that they own together, we determine that they have a spend down amount of $199,380 that they would need to spend in order to obtain Medicaid eligibility for Roger. A lot of times there's confusion as to how much Nancy, as the well spouse, would be able to keep as her protected resource allowance, especially if you are practicing in a state that is considered to be a minimum maximum state for purposes of determining the community spouse resource allowance. So if you look on our website and you see that there is a minimum community spouse resource allowance at $29,724, and there's also a maximum community spouse resource allowance at $148,620, you are in a state that is considered to be a minimum maximum state for purposes of determining the community spouse resource allowance. And so you would need to take the couple's total assets, the 350,000, you divide that number in half, and we would be arriving at 175,000. And because 1/2 of the total countable resources at 175,000 is greater than the current maximum of 148,620, Nancy would be capped at 148,620 as her community spouse resource allowance. If, for example, the couple only had $200,000 of combined assets and you divided that number in half, you would be getting 100,000, because that 100,000 is less than the 148,620. Then Nancy would be getting 1/2 of the couple's countable resources as her protected resource allowance. So sometimes that can cause confusion as to how you do that calculation if you are in a state that is considered to be a minimum maximum state. If you are unsure whether you're in one of those states, feel free to check our website. But also this map here is showing you all of the states that are in blue are considered to be minimum maximum states that you would need to do that additional step of combining the couple's resources and dividing that number in half to determine if they get to keep 1/2 or if the community spouse would be able to keep the 148,000 of assets. If you are practicing in a state that is in orange on the screen, then the calculation is a little bit easier because there is no minimum, or there is no taking half of the total countable assets. You just would have a maximum amount that the community spouse would be able to keep. So if you're in a state like where I live in Georgia, then you don't have to do that additional step. You just know that the community spouse is able to keep 148,620. This chart here is telling you, if you are in a minimum maximum state, the total amount of protected resources for individual as well as for the community spouse. So if you look at the very left-hand column, if you have a couple that has countable assets of 297,240 or more, then the community spouse would be capped at the 148,620. And then when you add the $2,000 asset limitation that the Medicaid applicant would have, the total protected resources in that case is 150,620. And then if you go down to the next row, the row that's in gray, and you have a couple that would have total assets between $59,448 and $297,240, then the community spouse is going to be able to keep 1/2 of the protected resource amount. And then when you add that half to the $2,000 asset limitation that the Medicaid applicant can keep, that's going to be the protected amount for a couple that has a range of assets between that 59,000 and 297. And finally, if you look at the bottom row in blue, a couple that would have $59,448 or less, they're going to be able to keep the minimum amount of $29,724. And when you add the $2,000 asset limitation for the Medicaid applicant, their total protected amount together is going to be $31,724. This again only applies to clients that are residing in states that are considered to be minimum maximum states. If you're in a state that is only has a maximum amount, then you don't need to do this calculation, because you just know that the community spouse is going to be able to keep the max of 148,620. If we go back to our example where we have a spend down amount of 199,380, we can immediately eliminate or convert that spend out amount of $199,380 into a Medicaid compliant annuity for Nancy. Nancy, because she is the community spouse or the spouse that is not applying for Medicaid, she would be the annuity owner, the annuitant, and the payee. With her being 80 years of age, she has a remaining Medicaid life expectancy of just over 9 years, or 109 months would be the longest annuity term that we could purchase for Nancy. So if we structure the annuity over 109 months and we put 199,380 into the annuity, the monthly payment is going to be $2,100 per month, and the total payout is going to be $228,900. The difference between the single premium going into the annuity and the total payout is going to be a small amount of interest that would be paid on the annuity policy by the insurance company. One practice tip that a lot of people ask me is how are legal fees and other like home repairs, buying a new car, funeral policies, how does those types of expenses impact the plan? We would reduce the spend down amount of $199,380 by any of those expenses that would need to be paid. So if there's legal fees of say $10,000 that need to be paid, or the family is planning on making home repairs at $20,000, buying a new car, things of that nature, all of those expenses are going to reduce the amount that would go into the annuity. So instead of purchasing the annuity for $199,000, maybe it would be closer to $160,000 after those types of expenses are taken into consideration. When the community spouse owns a Medicaid compliant annuity, Nancy as the community spouse is going to be the annuity owner. She's going to be the measuring life or the annuitant, as well as the payee on the annuity contract. The primary death beneficiary, like we talked about earlier, is most likely going to be the state Medicaid agency, to the extent that Medicaid benefits are provided on behalf of Roger. And the secondary or contingent beneficiary is going to be, in most cases, the children or a trust, a charity, or whoever the community spouse would want to name as a remainder beneficiary. Like we talked about earlier, there are a few exceptions to the state Medicaid agency being the primary beneficiary. If there is a minor or a disabled child, they can be listed before the state. And then also some states do allow for the institutionalized spouse to be listed as a primary beneficiary before the state as well. And if you are in one of those states where you are planning on naming the institutionalized spouse as the beneficiary on the community spouse's annuity, we would just need to make sure that the family was prepared to do some additional planning in the event that the Medicaid applicant would receive proceeds from the annuity contract if the community spouse were to predecease the Medicaid applicant. We do have a question here about the community spouse receiving the payments from the annuity contract and whether it would eventually cause the community spouse's resources to eventually exceed what the community spouse resource allowance is. This is a great question. We get questions about this all the time. So once the community spouse purchases the annuity and the Medicaid application would be submitted and you prove to Medicaid that the Medicaid applicant is spent down to the allowable limits and the community spouse is spent down to the allowable limits, then the Medicaid office can no longer look at the resources of the community spouse for purposes of determining eligibility for the Medicaid applicant. So a lot of times we have situations where the payments from the annuity will cause the community spouse's resources to exceed their maximum amount that they're entitled to, and that will not cause an issue for Medicaid eligibility purposes because they would no longer be considering the community spouse's assets in that application process. If you are worried about the payments from the annuity causing the resources to exceed their community spouse resource allowance while the Medicaid application is pending, you could always consider delaying the first payment for a couple of months from the annuity. So as long as we make a payment from the annuity within 1 year of the contract date, that would be considered acceptable. But also you could consider spending the clients down to something less than the $148,000 initially, so that when the payments are coming in from the annuity while the Medicaid application is pending, that's not going to cause an issue for causing the total assets to exceed the CESRA amount. So those are just some suggestions that we would be looking at when we're structuring the annuity and when we consider making payments from the annuity contract. A lot of times we get questions on why Nancy would be the spouse that's purchasing the annuity and why Roger, as the Medicaid applicant, would not be the owner of the annuity policy. The answer to that question is that the community spouse can have unlimited monthly income without having to contribute their income towards the Medicaid applicant's cost of care. If we were to structure the annuity in the name of the Medicaid applicant and their income is not being shifted over to the community spouse under the monthly maintenance needs allowance calculation, then the income from the annuity is just going to go towards the institutionalized spouse's share of cost or their patient liability. So most of the time we are going to suggest that the annuity is purchased in the name of the well spouse or the community spouse, considering they can have an unlimited amount of income and there are not any penalties for transferring assets between spouses. So you can have all of the assets transferred to the community spouse and purchase the annuity in the community spouse's name without having any kind of private pay or penalty period in that situation. If the community spouse does not have enough of their own monthly income by way of the monthly maintenance needs allowance calculation, then the community spouse is going to receive some of the Medicaid applicant's income before determining the Medicaid applicant's cost of care or their patient liability. An example of that is illustrated here on this screen, where we consider Nancy's income. She had Social Security income at $1,000 per month, plus the annuity that we created had $2,100 of monthly income going to Nancy. So her total income on a monthly basis was $3,100. And when we compare that to Nancy's monthly maintenance needs allowance at $3,715 per month, she has a shortfall each month of $615 that she is going to receive from Roger in order to make sure that she has enough of her own monthly income to meet her expenses if she is still residing at home. When we're determining Roger's patient liability or his Medicaid copay, we would be taking his income at $2,000 per month, subtracting out the amount that is shifted to Nancy at $615, and then also taking into consideration Roger's monthly personal needs allowance at $50 per month, and we determine that his copay to the nursing home is $1,335 per month. The economic results of the 109-month annuity plan was that Roger and Nancy were expected to pay $10,000 per month for his care, but by achieving Medicaid eligibility for Roger, we were able to reduce that cost down to $1,335 per month. And so the couple experienced a monthly savings of $8,665 each month by obtaining Medicaid eligibility for Roger by purchasing the Medicaid compliant annuity. The advantages of this plan is that we were able to obtain immediate Medicaid eligibility for Roger without any kind of private pay or penalty period. We also created sufficient monthly income for Nancy through the Medicaid compliant annuity, which would allow her to continue living in the community and residing in their family home. The potential disadvantages of this plan is that with the state Medicaid agency being the primary beneficiary on the annuity, if Nancy were to predecease the 109-month term, the state Medicaid agency would be entitled to the amount that they paid on behalf of Roger, but this would be at the Medicaid reimbursement rate versus the private pay rate. But in order to reduce the likelihood that Nancy would predecease the annuity term of 109 months, we could consider shortening the annuity term to something less than 109 months, which is usually what clients are going to be inclined to do, is shorten the annuity term so that they can accelerate how quickly the payments are coming back to the community spouse, and the community spouse can invest the money as they choose when they receive the payments back. If we assume Roger, the Medicaid applicant, passes away 6 months after the annuity is purchased, many times we get questions about what happens to the Medicaid compliant annuity. And in this case, absolutely nothing would happen to the annuity policy if the Medicaid applicant passes away, because Nancy was the annuity owner. She was the annuitant, or the measuring life of the annuity contract. So Roger passing away during the term of the annuity would have no impact on the annuity policy. So if it's questionable as far as how long the Medicaid applicant is going to live, and we don't want to stretch out the annuity policy for the full life expectancy of the community spouse, then we may want to consider shortening the term, because in a case like this, if we do the full life expectancy of Nancy at the 109 months and she's only entitled to $2,100 a month of income, and then Roger passes away shortly after that, him passing away is not going to trigger Nancy being able to get out of the annuity policy. Is just going to continue to pay for the remaining 109 months at the $2,100 per month. So if we want to make sure that Nancy has a greater monthly income amount than the $2,100, then we would consider shortening the term in order to accelerate how quickly Nancy is receiving that income back. If we instead assume that Nancy, the community spouse, passes away 6 months after the annuity is purchased, Nancy was the annuity owner and the annuitant. So in this case, we would immediately notify the insurance company that issued the annuity policy, and we would let them know that Nancy has passed away so that they will immediately stop making payments on the contract. With the state Medicaid agency likely being the primary beneficiary of the annuity, we would reach out to the state agency and obtain either a clearance letter or a letter that has the amount that they provided on behalf of Roger, and any amount that would be remaining in the annuity policy after the state is repaid would go to the children. In this case, were named as a secondary or contingent beneficiary, and they would have the right to either continue the monthly payments as scheduled for the 109 months, or they could receive a lump sum of cash at a discounted rate, or what's called a cash commutation amount, that they could choose to receive a one-time lump sum instead. We determined that the children in this case would be entitled to $152,790, and we determined that by taking the original annuity amount at $199,380 and subtracting out the 6 months of payments that Nancy would have received during her lifetime. So the 6 months times 2,100 is where we got the 12,600. And then also we subtracted out the Medicaid repayment amount, in this case of $33,990. This would be at the Medicaid reimbursement rate that the state is going to be repaid, which is why that prepayment amount or repayment amount, excuse me, is less than the $10,000 per month that the couple was paying prior to obtaining Medicaid eligibility. When we subtract out those two numbers from the original annuity purchase amount, we determined that the children in this case would be entitled to $152,790. And this amount is going to still be greater than if the couple didn't do any planning and they were just paying $10,000 per month for a 6-month time frame, because they would have been paying at the private pay rate versus the Medicaid reimbursement rate. A common misconception with annuities is that by naming the state Medicaid agency as a death beneficiary on the contract, that the state would be entitled to the full amount that's remaining in the contract. That is simply not true. We would be putting limiting language in the primary beneficiary field that would indicate that the state would only have a right to recover for the amount that they provide on behalf of the Medicaid applicant's behalf. And so in this case, the state only was entitled to how much they provided on behalf of Roger, and then the children received everything that was remaining in the annuity after the state is paid. To summarize the impact of each spouse passing away, the impact on the Medicaid compliant annuity when each spouse passes away, the institutionalized spouse passing away is not going to have any direct impact on the annuity policy because they are not named as the annuity owner or the annuitant of the contract. Also, when the community spouse, who would be the annuity owner and the annuitant, when they pass away, then the state is going to have a right to recover for their portion, and then the secondary or contingent beneficiaries will be paid after the state's claim is satisfied. If we consider a fact change where we consider Nancy's older age of 80 years of age and her poor health, she's worried that she's not going to survive the 109-month term. So we would consider reducing the annuity term to something less, maybe a 2-year time frame would be a time frame that she would feel comfortable receiving the payments back within 2 years. If we shorten the term to a 2-year time frame, Roger's total income is going to remain the same at $2,000 because he's not going to receive the payments from the annuity. But by shortening the annuity term, we're accelerating how quickly Nancy receives the payments back from the annuity contract. So instead of her receiving a payment of $2,100, it's going to increase up to $8,550 per month. And now with her income exceeding her monthly maintenance needs allowance at $3,715 per month, she's no longer entitled to receive any of Roger's monthly income under the MIMNA calculation. So Roger's copay to the facility in this scenario is going to increase from the $1,335 like we originally talked about up to $1,950 per month. The calculations that you're seeing here is really just adding Nancy's Social Security income at $1,000 plus the new annuity payment structured over a 2-year time frame at the $8,550, so that Nancy's total income is $9,550, and with her income exceeding the $3,715 for a monthly maintenance needs allowance, then she no longer has a shortfall because her income is exceeding the $3,715. So Roger's copay to the facility in this case is going to equal all of his income at $2,000 less a $50 personal needs allowance that he would be entitled to. Another fact change that we could consider would be to reduce the annuity term to something less than a 2-year time frame, something like a 3-month annuity in this case. So if we reduce the term down to 3 months, then Nancy's income is going to be $67,600 each month over a 3-month time frame. And so obviously with her income still exceeding the $37,515, she would not be entitled to receive any of Roger's income. So his copay to the facility is going to stay at the $19.50 per month if we reduce the term down to a 3-month time frame. I use this 3-month time frame as an example to point out that technically a 3-month annuity term would be considered actuarially sound because it is being paid out within Nancy's Medicaid life expectancy, but the payment amount of $66,600 per month could be viewed as abusive by Medicaid. So it would not be a term that I would usually recommend if we were going to be putting $200,000 into the annuity policy. So there's a lot of different factors that I would consider when determining the appropriate length of the community spouse's annuity. But as a general guideline, I usually consider the cost of care in that state when I determine how quickly the community spouse would be receiving payments back from the annuity policy. So for example, if you live in a state that the cost of care in your state is around $15,000 per month, then I would feel comfortable with the community spouse receiving annuity payments of $15,000 per month, because you could justify to Medicaid that if the community spouse needs care, they would have enough of their own income to cover their cost of care if that would become necessary. But once you get into creating $50,000, $60,000, $70,000 a month of income from the annuity, I think that that's a case for Medicaid to consider the annuity to be abusive, or to at least raise some red flags as far as how quickly the annuity is paying out on a monthly basis. In summary, shortening the annuity term is going to increase the annuity payment amount. Obviously, as you decrease the term, the payments are going to increase on a monthly basis. It also is going to decrease the likelihood that the income would be shifted from the institutionalized spouse to the community spouse under the MIMNA calculation, because if the community spouse's income is exceeding the MIMNA, then they're not going to receive any of the Medicaid applicants' monthly income because their income would be sufficient to meet the MIMNA amount. And also decreasing the annuity term is going to decrease the likelihood that the state will be able to recover against the annuity, because the quicker the community spouse receives the payments back, the less likely that the beneficiary designation is going to come into play. And if they received all the money back from the annuity policy and then the community spouse passes away, then there's not going to be any payment back to the state because the annuity is exhausted once the term is over with. Some of the factors that we consider when determining the best length for the community spouse's annuity: we're going to look at the health of both spouses. We're going to consider the spend down amount, whether we're dealing with a spend down amount of, say, $500,000 versus $50,000. We would also look at the couple's monthly income and whether we are trying to shift income from the Medicaid applicant over to the community spouse. And then also we're going to consider how quickly the community spouse needs the money back. If the community spouse has a monthly income need of $5,000 per month, then we would want to make sure that all of their income sources on a monthly basis, including the annuity, is going to meet that income need. And then finally, we would consider the type of funds that the annuity is being purchased with, whether it's a after-tax annuity purchase or a pre-tax annuity purchase. If we have a situation where clients have IRAs or other tax qualified plans that are going to be considered countable assets that need to be spent down, we can convert the couple's retirement accounts from a tax qualified IRA or retirement plan into an IRA Medicaid compliant annuity. If you are in a state that is in blue on the screen, then the community spouse's IRA is going to be countable if it would be considered countable, and we can consider using a IRA Medicaid compliant annuity in order to convert the countable IRA into a non-countable IRA Medicaid compliant annuity. We can do that by using either an IRA trustee to trustee transfer or a 60-day rollover in order to convert the retirement account into an IRA Medicaid compliant contract. We would consider how quickly we pay back the income to the community spouse when we're using retirement accounts, because if we choose a very short time frame, like a 6-month time frame on a IRA Medicaid compliant annuity, then the client is going to receive all of the income from the annuity within 1 tax year. So you're really not preserving any tax benefit if you structure that with a very short time frame when you're using IRA money to purchase the Medicaid compliant annuity. The timing to purchase the annuity for the community spouse, usually we want to have one spouse enter a facility so that a snapshot date is established and we determine that the community spouse is able to keep the maximum amount of assets. Once that has occurred, then we can determine the spend down amount, or how many assets need to be converted into non-countable assets. From there, the Medicaid compliant annuity would be purchased with the spend down amount, and then after the annuity is purchased, then the Medicaid application would be completed and submitted in order to obtain immediate Medicaid eligibility for the Medicaid applicant. Medicaid compliant annuities are always going to be considered a crisis planning tool and not a pre-planning tool, because the Medicaid compliant annuity is going to be irrevocable and non-assignable. So it does not offer any real flexibility once the annuity is purchased. And we also would want to wait until the snapshot date or the community spouse resource allowance amount is determined prior to purchasing the annuity, so that we are able to keep the maximum amount of resources for the community spouse and then spend down the excess resources with the annuity after the snapshot date has been established. And I know I went through the last part of the webinar fairly quickly because we were running out of time. If anybody has any questions, feel free to type those into the questions tab of the GoToWebinar. Also, if you have any questions afterwards, feel free to give us a call at the phone number you're seeing on the screen, or shoot me an email at amber@ashbur.com. I think I did answer the one question that we had during today's webinar, but if anybody, I'll stay on here for another minute or so if anybody has any questions for me before we run out of time. Okay, I'm not seeing any questions yet, but like I said, if you think of any questions, feel free to give me a call, shoot me an email. I'm happy to answer any questions that you have, and be sure to join our next webinar in the month of June. We're going to be doing a continuation on planning for married couples and when each spouse would consider purchasing a Medicaid compliant annuity. If you have any questions, feel free to reach out. Otherwise, thank you everybody for your time today and for joining today's session. Thank you and take care.